Hi, and thank you for tuning into my research. I'm Marc Younker, and this is Just Can't Debt Enough, Monetary Sanctions and Criminal Justice Reform. So the central question to my research is, what role do monetary sanctions play in the future of criminal justice policy reform that is rooted in equity? So monetary sanctions, also known as legal financial obligations or fiscal penalties, are composed of a defendant's costs incurred both during and after a criminal proceeding. These costs include fines, fees, surcharges, court processing, defense attorney payments, restitution, and even interest built upon prior unpaid sanctions. Monetary sanctions are imposed on all levels of the criminal justice system, ranging from traffic violations to the most serious federal offenses. Through this research, I look at the trajectory of monetary sanctions, beginning with debtor prisons and convict leasing. Our common understanding of monetary sanctions and development towards its contemporary function stems from the imposition of monetary sanctions in southern states during the 19th century. Southern states created a system in which incarcerated defendants were charged with an unaffordable amount of fees and fines and consequently leased to corporations who paid their legal debt in exchange for inmates' labors in coal and iron mines, as well as on railroads, quarries, and farm plantations. Over the decades, the money collected from convict leasing was historically used to fund the salaries of critical positions like sheriffs, judges, and officers in the justice system. Later on, we have the rise of neoliberalism in the 1970s and 80s. And the neoliberal politics and policies affirmed the principle in which each individual is held responsible and accountable for his or her own actions and well-being. This notion of personal responsibility resulted in the reduction of government intervention, ultimately causing mass insecurity for marginalized communities via wage stagnation and a lack of protection for labor's rights, and ultimately also causing state functions to find alternative methods to continue their operations because of the gap left by the government. This then bred an offender-funded model in the criminal justice system where defendants became responsible for filling the revenue gap the government left with the reduction of taxes in response to the notion of personal responsibility. And there's then, as time and trends have shown, an increased use of monetary sanctions imposed on defendants that is outpacing inflation in order to continue criminal justice operations. So this leads us to a bunch of issues I look at within my research, such as the criminal justice system is spending a lot more money to collect dispersed in various amounts in different states worth of legal debt from defendants who are already indigent or unable to pay, as 90% of defendants are classified as indigent within the criminal justice system. This also creates a conflict of interest as legal officers or law enforcement officers are battling between enforcing the law and understanding that enforcing the law will also mean their job has a security for their salary or whatever benefits or tools or operations are funded by monetary sanctions. It also breeds an issue of inequity altogether, which is the main focus of this research, because the collateral consequences and inescapable debt is much worse for marginalized communities, predominantly poor Black communities, that the criminal justice system tends to target because of their socioeconomic demographic, and knowing that this community can be stuck in a cycle of funding the justice operation. So how does this work? We begin with courts charging fees for filing and fining people as punishment, and these costs often result in the accrual of large debts. Then litigants are unable to pay the court, and late fees and extra fines are added to the unmet payment demands. So these fines and fees and costs support a system where our poorest community members are subject to repeated court appearances and potentially additional jail time. And once they're caught in this cycle, it can be very difficult for the defendants to emerge from the criminal legal system, regardless of their original crime of conviction. This breeds inequitable outcomes between defendants that are wealthy and defendants that are poor. In this table, I'm showing a list of how monetary sanctions are dispersed into funding different state operations, predominantly criminal justice operations. So, for example, $15 goes towards court automation, or $5 going to electronic citations. $150 is funding DUI analysis fees. And this is in Illinois County, which is also the main focus of my research in looking at how policy reform can make the criminal justice system equitably finance itself without inequitably having disadvantageous impacts on poor communities. So the methodology for my research is that I did a case study analysis of legal debt and statutory reform in the state of Illinois through a framework of equity. I evaluated the Criminal and Traffic Assessment Act and the findings of the Statutory Court Fee Task Force by using equity as a measure of outcomes, looking at different socioeconomic demographics for legal debt accumulation, race, and recidivism. Overall, monetary sanction reforms, from my research I learned, will play an instrumental role of shifting the criminal justice system from harmfully anti-poor and Byzantine methods to becoming an equitable environment that transparently treats all individuals engaged in the system with a holistic care specific to their needs. As I mentioned earlier, Illinois was my prime model to analyze monetary sanctions, especially in regard to reform, because Illinois has authorized over 90 different fines and fees and justice-related costs without any limitation on the number of sanctions in which a defendant can be charged. So looking at the Criminal and Traffic Assessment Act, I learned that that the reform is necessary because it distinctly defines assessments, fines, fees, and indigents. It standardizes legal financial obligations into 13 schedules of assessments for criminal and traffic offenses, while also placing a maximum cap on the amount of money that can be assessed under each schedule and for various services or filings within the court process. The CTAA, or the Criminal and Traffic Assessment Act, allows Illinoisans whose income is below 200% of federal poverty guidelines to be eligible for a full waiver of the monetary sanctions they are assessed, while those who make up 400% of the poverty level are eligible for a sliding scale reduction in the percent of their fines and fees they must pay. This reform is really critical to implementing systemic equity because it ultimately allows the ability to pay to be factored into a defendant's sentencing while simultaneously weakening the discretionary powers judges hold on imposing monetary sanctions. It also grants poor people and people of color greater protections from the collateral consequences of legal debt in the same way that wealthy defendants have little risk because their financial standing is non-indictment on the rest of their lives. In essence, Illinois statutory reform is moving towards an equitable criminal justice policy, but it is not enough. It only really provides a short-term relief for indigent defendants and slightly closes the equity gap. But the CTAA is scheduled to go out of effect in 2022. Knowing that the CTAA was able to progressively alter criminal justice operations to equitably suit the circumstances of those unable to afford monetary sanctions within 2 years, I believe that the CTAA should be reauthorized and fellow states should look into establishing an entity similar to the Illinois Statutory Court Fee Task Force in order to implement equity-driven legislation. I also believe and recommend that states across the country increase transparency about court costs. Monetary sanctions is an unexplored area in the criminal justice system, but its impact is so widespread. And I believe that with increased transparency on court costs, we can understand how there are discrepancies in the way it impacts different defendants. I also encourage statewide conformity, consistency, and uniformity in court assessments, and this comes directly from the Criminal and Traffic Assessment Act used in Illinois, as conformity, consistency, and uniformity in court assessments also helps bring about equitable outcomes for different defendants. And the CTA also from the CTA also recommend a decrease of reliance on system users to support court operations, knowing that it allows us to relook at which functions are really necessary for criminal justice operations and how state budgets can be reallocated to make sure that's focusing on crime that truly causes harm to communities. I believe that a combination of legislative action can really make a large impact on criminal justice or equity-based criminal justice reform. This includes fully funding state court systems and forgiving legal debt widely. For instance, the city of San Francisco forgave $32.7 million in outstanding legal debt, to which the mayor's budget office calculated that the benefits of this decision far outweighed the costs. And it reduced the threat that monetary sanctions pose against the city's most marginalized communities. I also believe reparations is a part of a process that is necessary for creating or really having an equitable impact through criminal justice reform, policy reform. This legislative reform appropriating reparations would most significantly assist in addressing the racial wealth gap that is so prevalent throughout this country. And I don't think criminal justice reform regarding monetary sanctions could ever be equitable unless reparations is included in the policy agenda. The future of the criminal justice system and all government administration really relies on the integrity of the threads that hold the system together and allows it to function properly. Monetary sanction reform needs a framework of equity if the criminal justice system intends on being trusted as an institution that can administer public safety and safeguard the right to life, liberty, and opportunity for all people, especially the people who are this country's most marginalized and most needed by the republic as it stands. Thank you for listening, and I hope you have a great day.